There was a lease on the evidence table in front of me. A standard residential lease, the kind you can download from any landlord's website, fill in the blanks, print it out, 2 pages. The font was small, the paragraphs were long. It was the kind of document designed to look comprehensive and to be read by as few people as possible. I have seen hundreds of them in this building. I know what they say before I read them because they all say the same thing. The tenant owes, and here is the list of everything they owe, and here is what happens if they do not pay it. I want to tell you what this lease said, and then I want to tell you what the man who brought it into this room believed it entitled him to do. The plaintiff in this case was a landlord. I will describe him the way the record describes him, which is the only way I describe anyone in this room. He owned several residential properties in this city. He had an attorney, a careful, prepared attorney who had clearly handled proceedings like this before, and who presented his client's position with the kind of practiced smoothness that comes from having made similar arguments many times. He wore a good suit. He sat straight. He had a file in front of him that was organized. He had, by every external measure, the appearance of someone who expected to be here for a short time and to leave having gotten what he came for. On the other side of that room was a woman in her early 60s. She had driven a considerable distance to be here. She was not represented by a large firm. She had a single attorney beside her, the kind of attorney who takes cases like this one, I have learned over 9 years on this bench, because they believe in them, not because they are profitable. She had a folder in front of her, not a legal binder, not a professionally prepared file, a folder, the kind you buy at an office supply store, and that folder was full. I noted this before anyone spoke. I have been in this building long enough to know that a folder organized by a grieving daughter means something specific. It means her mother taught her something, or her mother left her something, or her mother was the kind of person who understood, even at the end of her life, that the record would matter. The woman in that folder's chair was there to represent her mother's estate. Her mother had been a tenant in one of the plaintiff's units for 11 years. She had paid her rent, kept her unit, and made her requests for maintenance in writing, as the lease required. She had done this for 9 years without interruption, and then her health had declined, and then she had died. And 14 days after she died, 14 days, the man across the table from her daughter had filed this suit. I want you to hold that number, 14 days. I am going to come back to it. The claim was straightforward on its face. Unpaid rent for the final several months of the tenancy, late fees that had accumulated, and damages to the unit totaling $1,200. The plaintiff's attorney argued that the lease obligation did not terminate at death, that the estate remained liable for the amounts owed, and that the damages to the unit were documented. He had photographs, he had receipts, he had the lease. What he did not have, and what I suspect he had not anticipated anyone producing, was what was in that folder. I had read the file before anyone walked into this room. This is not unusual. It is what I do before every proceeding. I read the file, all of it, the complaint, the response, the exhibits, every page the plaintiff submitted, and every page submitted by the estate. I had read it the night before, and I had read it again that morning. And I want to tell you what I found on the pages that the plaintiff's attorney, apparently, had not read as carefully. The move-in inspection, signed 11 years ago, documenting the condition of the unit when the tenant first arrived, and listed on that inspection, in the plaintiff's own handwriting, on the plaintiff's own form, several items in a state of pre-existing wear. A scuff along the hallway wall, a kitchen cabinet door that did not close flush, a bathroom hinge that had been noted as needing replacement. All of it there, dated, signed by both parties. 3 of the 5 items the plaintiff was now claiming as damages had been present in that unit before his tenant ever moved a single piece of furniture through the door. I set that inspection beside the photographs he had submitted. I set them side by side and I looked at them for a long time. And I thought, he submitted both of these documents to this court. The same man, the same file. I want to tell you about the first moment that changed how I understood what I was watching. The plaintiff had organized his case around a simple premise. The lease was a contract. The tenant had not fulfilled the contract, and the estate owed the balance. He was not wrong about the legal framework. That framework exists, and under certain circumstances it applies. I have enforced it. The contract does not dissolve simply because a party to it dies. The plaintiff's attorney knew the law, and he had applied it correctly as far as the law went. What he had applied it to, however, was a unit that had not been legally habitable for the better part of the tenant's final year. I want to be specific about what I mean by that, because habitability is a word that gets used loosely, and I do not use words loosely in this room. There is a heating violation on record for this unit. It was issued by the city's Housing Inspection Department in the month of February, a year and some months before the tenant's death. The citation identifies the heating system as inadequate to maintain minimum required temperatures in the unit during winter conditions. The citation was issued following a complaint. The complaint was filed by the tenant, in writing. The date of the complaint is on the filing. The plaintiff received the citation. His name is on the notice. His address is on the notice. He was required under the municipal code to remediate the violation within a specified period. Now I want to tell you about the photograph. The daughter, testifying from the stand, produced a photograph from her folder. She had taken it herself on a visit to her mother that February. She had taken it because her mother had called her and told her the heat was not working. The photograph showed the thermostat in the unit, digital display, clear. The temperature in the unit on that day, at the time the photograph was taken, was 54 degrees. Her mother was ill. She was elderly. She was living in February in a unit whose landlord had received a city citation for inadequate heat and had not addressed it, in a space that registered 54 degrees on her daughter's phone. I looked at that photograph for a long time, too. The daughter had organized her folder the way her mother had organized her records, chronologically, tabbed, each exhibit labeled in a handwriting that was careful and unhurried. I could see, watching her remove each document and pass it to her attorney, that she had done this more than once. She had practiced. She had sat at a table somewhere, or on a floor, or at a kitchen counter, in whatever space she had found in the weeks since her mother died, and she had gone through her mother's papers and she had assembled this. The plaintiff's attorney objected to the relevance of the heating violation when the daughter's attorney moved to introduce it. He argued that habitability was a separate matter from the unpaid rent, that it had been addressed through the administrative citation process, and that this proceeding concerned only the contract. I overruled the objection. I want to explain why, and I want to explain it the way I explained it in my ruling, because the reasoning matters. If the unit was not legally habitable, the rent was not legally owed. Not some of it, not a reduced amount, but the full amount, for the full period of the violation and the remediation failure. The habitability standard is not separate from the lease obligation. It is the condition under which the lease obligation exists. A landlord who has failed to maintain a habitable unit has not fulfilled their side of the contract. A tenant living in an uninhabitable unit does not owe rent for the period in which the unit failed to meet that standard. This is not an obscure corner of the law. It is not a technicality. It is one of the oldest protections in residential tenancy. The idea that the payment of rent is contingent on the provision of a home that actually functions as a home. The plaintiff's attorney had presented the lease as if it were a one-way document, as if it said only what the tenant owed. He had apparently not read the full legal framework within which that lease operated, or he had read it and believed that the death of the tenant and the subsequent vulnerability of the estate meant that no one would raise it. He did not know about the folder. I want to tell you what happened when the daughter testified. I want to tell you about the specific quality of her presence in that room, because it matters to what I am about to say. She was not emotional in the way I might have anticipated. She was not tearful. She was not trembling. She had clearly made a decision, somewhere in the weeks between her mother's funeral and this proceeding, about what she was going to be in this room. She was going to be accurate. She was going to be organized. She was going to answer every question directly and produce every document at the right moment. And she was not going to give anyone in that room the impression that her grief had made her anything less than fully capable of defending her mother's estate. When the plaintiff's attorney cross-examined her, he asked whether she had any documentation that the heating violation had gone unaddressed beyond the citation date. It was a reasonable challenge. Citations are not proof of ongoing failure. She reached into her folder and produced a second photograph, and a third, each dated, each showing the same thermostat in the same unit on different days across a period of 6 weeks following the citation date. The temperatures varied. None of them met the minimum required by law. Her mother had taken 2 of those photographs herself. I want to sit with that for a moment, because I have been in this building for 22 years, and I have sat in 3 chairs in this room, and I have seen a great many things presented as evidence. And I do not often find myself sitting with something, but I found myself sitting with that. A woman who knew she was ill, who knew her health was declining, who understood at some level that the months ahead were uncertain, took a photograph of her thermostat, dated it, kept it. She was not a lawyer. She had not been advised to do this. She did it because she understood, from 11 years in that unit and 17 written maintenance requests and 1 city citation, that the record would matter. She built the record herself, in the margins of a life that was running out of time. The plaintiff had filed this suit because he believed a dead woman could not defend herself. He was wrong. I am going to tell you about the moment the proceeding turned, not the ruling. I will get to the ruling. The moment before the ruling, when the case stopped being what the plaintiff had imagined it would be and became what the record required it to be. It was when the daughter passed the 3rd thermostat photograph to her attorney, and her attorney entered it as an exhibit, and the plaintiff's attorney asked for a moment to consult with his client. He stepped back from the table. He spoke quietly. I watched the plaintiff's face during that consultation. I have watched many faces in this room across 9 years on this bench. I know the face of someone recalculating. It is a specific expression, not panic, not remorse, but the expression of someone who has been running a calculation for weeks and has just discovered that one of the variables they had assumed was fixed is, in fact, not fixed at all. He had assumed there were no photographs. He had assumed the folder was thin. He had assumed that 14 days after a funeral, a grieving daughter would not have found what her mother had left her. I proceeded. The ruling was this. The plaintiff's claim for unpaid rent was denied in full for the period of the documented habitability violation and the unaddressed remediation failure, a period that encompassed all of the months for which rent was claimed. The late fees were denied in consequence. The damages claim was denied. The move-in inspection established pre-existing conditions for 3 of the 5 items. The remaining 2 items fell within normal wear and tear for an 11-year tenancy, a standard the plaintiff had also failed to meet. I did not stop there. I sustained the estate's counterclaim for the value of rent paid during the period of the habitability violation. The daughter's folder had provided the documentation. Her mother's records had provided the dates. The city's citation had provided the legal basis. I awarded the estate the sum that had been paid during the months the unit did not meet the legal minimum. The plaintiff left this room owing money. Not a great deal of money in the absolute sense, but a great deal of money for what it represented, which was the accounting of 11 years of a woman's tenancy against a landlord who had filed a lawsuit 14 days after her funeral. That is what he did not expect. Not the ruling itself, the record. The fact that his own submission to this court contained the move-in inspection that contradicted his damages claim. The fact that the heating violation was in his file, and in the city's file, and on the thermostat photographs that a dying woman had taken and dated and kept because she understood that the record would matter. He had brought this suit believing the record was on his side because he had not read all of it. I have said this to my clerks, and I have thought it more times than I have said it. The record does not stop when the person does. The documentation persists. The maintenance requests persist. The photographs persist. The move-in inspection persists. A person can die and the record of their tenancy continues to exist, and if that record was built carefully enough, it answers for them in rooms they will never enter. Her record was here, it was complete, and it answered him. I want to tell you something about what it takes to build a record like that, because I think it is the thing this case is really about. 9 years as a public defender in this county taught me that the people who most need the legal system to work for them are often the least equipped to navigate it. They do not know what to document. They do not know that the maintenance request has to be in writing, and the writing has to be dated and kept. They do not know that the move-in inspection is a legal document, and that the condition noted on it will matter years later if there is ever a dispute. They do not know these things because no one has told them, and because the people who design these systems frequently do not design them to be navigated by someone who has never needed to navigate them before. This woman knew, or she learned, across 11 years and 17 written requests and 1 city citation and a declining body and a thermostat she photographed in February. She knew. And she left what she knew to her daughter in a folder, and her daughter organized it, and her daughter drove here and sat in that chair and presented it to this court. That is what integrity looks like. Not the grand version, not the dramatic version, the version that happens at a kitchen table in a folder bought at an office supply store by a woman who understands that the record is the only thing that will be there when she is gone. I have been in this room in 3 different chairs across 22 years. I have defended people who needed someone to know their record before anyone else had read it. I have prosecuted cases where the record revealed what no one was willing to say aloud. I have sat on this bench and watched the record do its work in both directions, confirming guilt, clearing names, settling what years of disagreement had left unresolved. The record does its work. If it exists and it is complete, it does its work. What this case confirmed for me is something I have believed for a long time, but do not always find expressed this clearly. The record is not a legal instrument. It is an act of faith. The tenant in this case built a record over 11 years because she believed that someday, in some room, someone would read it and it would matter. She did not know which room. She did not know when. She kept it anyway. I am the someone. This was the room. It mattered. After I delivered the ruling, I did something I do not always do. I addressed the daughter directly. Not at length. I do not make speeches from the bench. I said, "Your mother kept her documents. That is why you are leaving this room with what you came for." She nodded. She did not cry. She had already decided what she was going to be in this room, and she was it until the last moment. I think about that folder. I think about the organization of it, the tabs, the handwriting that was careful and unhurried. I think about a woman at a table going through her mother's papers and understanding what she had been given. Not money, not the absence of grief, a record that was complete. Tell me about someone who kept the records, someone in your life or someone you heard about who held on to the documentation when it would have been easier not to, who dated the photographs, filed the copies, kept the receipts in a folder that was ready when the room finally required it. Write it in the comments. I read every one of them. And I want to know what those records made possible when the time came. If what you heard today is the kind of thing you have been waiting to hear said clearly, in a voice that comes from inside these rooms rather than outside them, I would be glad to have you here. Subscribe, hit the bell. What I bring to this channel is the same thing I brought to that bench for 9 years, and to the public defender's office for 9 years before that. I read the file, all of it, every page, because the record is the whole case, and every case deserves someone who knows that. Her mother knew it. Her mother built a record that answered a lawsuit filed 14 days after her funeral, in a folder, tabbed, labeled, waiting. That is the case. That is what I wanted you to see.